Welcome back. You know, he's a legal genius. My Taekwondo instructor, Will Worsham, is back for this week's Speaking Legal Discussion.
You still need to come back for your second lesson.
Oh, well, starting in January, I'll have some more free time.
Okay.
So I'm starting in January. I'm hoping to get in there and learn some stuff.
Well, you broke a board the very first time, so
my
I'm
first
going to
time.
say that you should be encouraged.
Now, does everybody do that their first time, or am I special?
Well, that's part of what we do with the intros with folks, is we teach them how to break a board, because we want people to know that they can be successful.
Right.
Because a lot of times taking a martial arts beginning is an intimidating thing. We can show you right away that we can teach you something, you can be successful, and this is going to work out for you.
I have to tell you, Will, I had so much confidence for a week after that.
Just a week.
Just 1 week. I felt really good about myself.
Because I was worried he wouldn't be able to do it, and he did it right away, and he gave me confidence.
That's
No problem.
exciting.
All right.
Okay. We do have a legal question for you, though,
Yeah,
too.
what are we doing here?
Sure.
Okay, today's legal question. My son's case is set for a preliminary hearing. What is going to happen? So I'm guessing she's asking what happens at a preliminary hearing.
Sure, yeah.
Can we start with what a preliminary hearing
That's
is?
a great place to start.
Okay.
So in Missouri, as in most states, when a felony charge is filed as opposed to a misdemeanor, there's two different ways a felony charge can be filed. Either a grand jury can render an indictment, and it goes straight to circuit court. But the more normal process that happens here, at least in this part of the country, is a prosecutor files what's called a felony complaint. Before it can go into circuit court, that complaint is going to go first to an associate circuit court, and a judge has to rule at a preliminary hearing that there is at least probable cause to believe a felony was committed and that the defendant committed it. So it's not a finding of guilt, it's just a finding of, hey, I've heard some basic evidence, and there's a reason to put this person on trial.
So the prosecutor, the person bringing it, thinks they have enough information to take it to this judge to say if it's a felony or not, or if the person committed it or not.
Right. Well, generally a prosecutor is going to feel pretty confident that they can not only get past a preliminary hearing but obtain a conviction, or they're not going to file the case.
Because it saves time and money.
Right. This is just kind of a check to make sure that a prosecutor can't put people on trial for felonies without at least somebody going, there's a reason to do that. We don't want to put people through the time, expense, pressure, stress of being on trial for a felony crime without some sort of check and balance in the system. And that's what this is. It's either a grand jury decides that this needs to go to trial, or a judge hears some of the evidence, like a grand jury would, and decides that, yeah, this case can go on to trial. So that typically is called being bound over to circuit court. You may have heard that term.
So her son is basically being charged possibly with a felony then?
Yeah,
is what you're
this
saying.
person has been charged with a felony.
Okay.
So this is a felony offense. It's in the very preliminary stages, so we have a preliminary hearing. So likely there'll be maybe a reappearance. The lawyers on both sides will maybe talk a little bit about some of the things, but ultimately, for the case to go forward, either this person, her son, is going to have to either waive his right to a preliminary hearing, which happens in a lot of cases, just say you don't need to put that evidence on, I want to go ahead and get into circuit court on this, or a short hearing, usually lasts an hour or two, will be heard where some of the evidence will be brought forward, just enough to convince a judge that, yeah, this needs to go forward. It usually doesn't take very much.
How long is a preliminary hearing usually?
A couple hours, maybe.
A couple hours?
Yeah.
Now, so the evidence of a preliminary is going to be a lot less, the burden of proof is going to be a lot less than
because
the
it's
actual
only a
trial.
probable cause standard, which is more likely than not, as opposed to a finding of guilt verdict, which is going to have to be beyond a reasonable doubt.
Exactly.
So when does the indictment happen? Is the indictment before that preliminary hearing or afterwards?
An indictment only happens if there's a grand jury involved. So in this process we're talking about today, there's no indictment. Instead of being a felony indictment, it's actually referred to as a felony information, and that would be filed after this preliminary hearing stage, so once it goes into circuit court. So it starts as a felony complaint in the associate circuit court, goes through that process. Once we get past the preliminary hearing, then it becomes a felony information is filed. Usually looks identical to the felony complaint, except for its title is a felony information.
Gotcha.
But that's actually the formal criminal charge.
No wonder you can remember how to speak Chinese. I mean, your brain is just, seriously.
We're just working on the Chinese. It's a new project, but
yeah,
anyway.
well, good so far. Yes, that's all right.
That sounds kind of complicated.
Well, it is, but it's not. I mean, it's just the process that it goes through. You just have to think of it as we're going to take a couple of stages, and one of these stages is we're going to make sure there's a reason to put somebody on trial. That's what I really like about the system is there's at least somebody, a stopgap in there at some point that can say, hey, wait a minute, this shouldn't go any farther. I'm going to put an end to it right now. And the associate circuit judge can do that to an extent. The only flip side of that is because it's not actually a trial, jeopardy has not attached, and so the prosecutor is free to refile that case and start that all over again. But they still have to be able to get past a preliminary hearing, and in order to do that, they'd have to be convinced that something went wrong in the preliminary hearing, some witness didn't show up, or maybe they've got some new evidence that they need to bring, and now they can bring it forward.
Gotcha. If people want to find more information for you?
Here at the station, wworsham@color10.com, or our website, www.willworshamlaw.com.
Thanks so much, Will.
Thanks.
We'll be right back.